May please, Your Lordship. The Lordship has granted permission yesterday, my lord, for listing a repetition today, my lord, but it was not listed. Kindly, my lord, tomorrow, my lord. Obliged.
Please, Your Lordship. With the consent of other side, I beg to mention item number 2 and 3, Lordship.
2 and 3.
2 and 3, Lordship. In this matter, we are likely to produce some certain instruction, Lordship. We need to have 1 week time, Lordship.
You are for?
Respondent number 4 in item number 3.
Okay. Who is there in the petitioner? For the petitioner? Mr. You are
RL Sutia,
in item number 2.
2, Lordship.
Okay, Mr. R.L. Shutial, Landed Counsel for the petitioner. Mr. A. Aforesaid, Landed Standing Counsel Revenue and Disaster Management Department, and Mr. J. Bora, Landed Revenue Government Advocate for the state respondents are present. Mr. M. K. Bora, Landed Counsel for the respondent number
4 in item number 3.
3 has sought for listing of the case after 1 week in order to
Produce certain instructions, Lordship.
okay, in order to obtain certain instructions in a matter. So as the prayer is made with the consent of the land council for the other parties, the prayer is allowed, release the cases on so and so.
8 September 0809.
Obliged.
May I please, Your Lordship. My lord, item number 4, that Panchayat election matter, my lord. My lord, I am going to file additional affidavit in this case, Lordship. My lord, I could serve the copy to the state gov and the private respondent. My lord,
Okay, I will allow, just let it reach.
I am praying for requisition of the affidavit.
No, how can this certain documents?
Additional affidavit that was-
Yes, is it possible for the court to look into the additional affidavit during the course of the hearing? Let it reach, then we'll decide.
Obliged.
May it pleases your lordship, with the consent of the other side, I beg to mention item number 11, your lordship. Lordship, the matter may kindly be taken up after 3 weeks, your lordship.
Okay. Who is for the petitioner? You are for the petitioner?
Petitioner.
And who is for the respondent?
Lordship.
Okay, Miss
S. Sarkar.
S. Sarkar. This is a GST matter of 2018.
Yes.
S. Sarkar, Landed Counsel for the petitioner, has prayed for an adjournment with the consent of the Landed Counsel for the respondents. First of, what is the ground for adjournment?
Lordship, my senior is out of station for medical treatment, your lordship.
It is submitted that the Landed Counsel wish to make submission is out of station due to medical review. In view of the ground cited, the request for adjournment is allowed. Raise the case after 2 weeks on a date to be fixed by the office.
May it please, Your Lordship, I beg to mention item number 7, my lord. Senior has some personal inconvenience today. My lord. Item 7.
2015 matter.
My lord.
You wait.
Your lordship, with due respect, I would like to mention the listing of a writ petition number 4349/2026 for tomorrow. The matter is in a motion form, and due to unavoidable circumstances, on the last date, it has been adjourned. So kindly please.
Friday.
Friday.
Me, please, your lordship. I beg for listing the matter, lordship. Matter relates to land acquisition, lordship. It was last listed.
Please
on
give it to the court master.
May it please, Your Lordship, I beg to mention for listing of a writ petition earlier. Actually, I am led by the outstation counsel, so he will be on Monday in Gauhati. So matter may be listed on next Monday, Lordship.
Please give it to the court master.
Deeply, please.
Supplementary list for motion, item 12.
The issue concerns a decision by the GMDA for demolition of the boundary wall. And I say that all possible measures have been proceeded as per law. There's nothing wrong with that. Only one thing, if I may address your lordship. So far as the existence of the boundary wall is concerned, it was prior to the NOC. After the NOC in 2010, we had to relinquish 4 kathas of land, 4 acres of land, and therefore it has to be realigned. Now, the boundary wall was then prior to the GMD Act coming in force. I'm not on the legal point. They do not have any objection as to the presence of the boundary wall. They're insisting on the no NOC. NOC was not required earlier, and therefore this all along we have been pleaded. Now, only thing, Milo, if ex post facto permission can be granted, if things can be aligned in order, it's nothing.
Ex post facto, who is the authority?
Now, the executive officer, chief executive officer, GMDA, is the authority because nothing so huge has taken place. And so
No,
far,
no, what is the proceeding earlier?
earlier proceeding was that they issued a show cause notice in 17.
Let us see the
My
document first.
My lordship. The first notice was issued, Milo, at page 20. May I read that, Milo?
Yes.
Whereas you have undertaken or carried out development of the boundary wall and land within GMDA area covered by master plan and zoning regulation in the manner and at the place as specified in the schedule below, without obtaining NOC for erection of the compound wall and thereby contravening the provision of section 24 and 25 of the GMDA Act. Now, therefore, you are hereby directed under section 87 of the Act to stop forthwith the deviated construction of the boundary wall and show cause to the undersigned within 10 days of receiving of notice why the construction made without obtaining NOC should not be demolished under section 88(1) or seal the premises or the authority's erection work in such work being carried out completed under section 88(4). Your reply must reach within 10 days of service of this notice, failing which DMDA will be free to go ahead with demolition of the deviated building construction of the same premises below. Following this, the order at page 21 was issued below. The third paragraph in my read below, the last one. Therefore, I, Srimati so-and-so, I, so-and-so, do direct Padma Kolita, that's me, Miller, house number 59, so-and-so, demolish the unauthorized construction of boundary wall, constructed in violation of GMD Act, building bylaws, and the zoning regulations within 5 days upon receipt of this order, failing which GMD will be free to proceed with the demolition of the unauthorized portion of the building on its own without giving any further intimation, and expenses thereof shall be recovered from Padma Kolita. Padma Kolita hereby informed that this order will take effect without prejudice to any other punishment that can be inflicted under the relevant provisions of the GMD Act 85 for such violation. But then I filed an appeal before the GMDA, following which this communication at page 7318 was issued. This was issued by the town planner, whereby it was stated that I should approach the district and session judge Kamrup Metro. I approached the district and session judge Kamrup Metro by the following page, filing an appeal against the demolition. That's at page 23. The learned district judge, at page 33 of the appeal memo, that's the order part. Page 33. After 6 years, was of the view that appeals would lie before the Board of Revenue Assam. And therefore, on the count of maintainability, the appeal was dismissed.
Now let us see your grounds
My lordships.
in the appeal.
In the case, my lordships. In the appeal, lordships. Appeal memo I can give you, the
No, it is reflected.
reflected lordship. 26. 1. May I read mine? For that the respondent issued notice dated 6/7/17 without inquiry and proper verification of the construction.
Where is your reply to the so-called notice?
Yeah.
No, it is there in the ground. Let us see.
And
Let us. No, we'll not look into
But-
extraneous document now.
For that, the respondent issued notice dated 6/7/17 without inquiry and proper verification of the construction works, and the impugned order dated 11/8/17 was thereafter it was issued. The impugned order has no such foothold in the eye of law and is liable to be set aside. 2. For that, the replies dated 18/7/17 furnished by the appellant pursuant to the notice in 17 were not given any weightage, nor got verified thereafter, for which the impugned order is liable to be set aside. For the reply furnished on 18/7/17 were exhaustive and were true and correct pictures. No official to respondent visited site to ascertain the position after receipt of reply. This has turned the order totally imperfect and infertile as such. For that mere perusal of the notice dated 6/7/17 and the imprint order dated 11/8/17 have proved conclusively that no official respondent visited the site before issuance of notice. No query was made to the applicant. The imprint notice as such was served summarizingly. It is therefore liable to discard by the authority.
Now, after that, suppose Board of Revenue here said wrongly or correctly. Did you file any?
No, we did not go. But what
Did you challenge this order
It was
immediately?
no, we did not do so.
But
Thereafter,
when the order was passed,
24 in the year 24.
then
That was 33.
you allowed this order to remain.
Persuaded the matter at page. Well, after that, it just came the order at 52. There was a similar order in case of my house also, but there the learned district judge proceeded to discuss and decide the matter. Now came 52 after both the orders. I understand, my lord. It is not the procedure was not followed. Every nook and corner was looked into.
So you allowed this order to remain, judgment,
That you go to revenue.
2024.
Yes. True. I understand. As it is true. Now, page 52. The executive officer concerned, me of the authority. May I just read that order? Whereas notices were issued to you on 6/8/17 for removal of unauthorized construction of RCC building and right number so and so 6/8/17 for removal of a boundary wall constructed in violation of the building bylaws. Whereas order passed by Honorable Additional District Judge number 133/24 on Miss Appeal number 14/18, another order passed by Honorable District Judge 16/5/24 on Miss Appeal 13/18. In pursuance of the above, you are asked to demolish, remove the unauthorized construction in portion of the construction constructed in violation of GMD Act so and so within 5 days from date of receipt of this letter, failing which GMD will be free to proceed the demolition of the unauthorized portion of the building and boundary wall without giving further intimation. Expenses thereof shall be recovered from Padma Kalita and others. This is a fallout of this 24 order, which was reflected in this communication. Thereafter, 9th October, I had written to the Chief Executive Officer. That's on the next page.
But this order at page 52 is a consequential order pursuant to the judgment of the appellate court.
So far as the appellate court,
How then things
Appellate-
can be changed?
appellate court did not interfere with the
So your duty was to challenge that.
true. Since the delay of 6 years interregnum was due to the authorities themselves, in 2018 they had directed us to go to the district judge, London district judge, which we had filed. End of it, Honorable District Judge had said that no, the jurisdiction lies with the board. Thereafter, they followed up with the matter. And therefore, we say, my lord, so far as it is not the alignment, it is only that the boundary wall existed all along. Just on the
Oh, we cannot go into
No,
the
no,
question
no,
of fact. Why you are saying so?
nothing. What I am on is that, my lord, before demolition, if they
The
explore that,
appellate court says appeal is not maintainable,
my lord,
right? On what ground, I do not know.
the notification was issued there, my lord, in the appellate court's order. My lord.
No, a GMD appeal.
Notification would have page 33.
GMD appeal is not. A GMD is a notification. এই যে এটা এই যে এপিলৰ যাব যে দিওঁ Mr. Bonik,
My lordships,
page 33.
my lord. My lord.
This notification
Notification.
of
Yes,
1994
yes.
has been changed.
But on that,
1 minute, 1 minute
lordship,
in 1996. Right? And appointing district and session judge Kamrup as the appellate authority
My
in
lord.
place of Board of Revenue.
My lordships. Lordships.
So this, the proceeding of the appellate court that it had no
My
jurisdiction
lord.
is erroneous.
Erroneous.
It had the jurisdiction
My lord.
since 1996. He referred to a notification of 1994 to hold that Board of Revenue was the appellate authority.
My lord.
But 1996 notification, 22nd August, it says District and Session Judge Kamrup Gauhati is the appellate authority. So you better seek review of this judgment.
Well, I pray some protection because
What
happened-
protection?
Well, tomorrow,
You
tomorrow the
for
demolition,
2 years.
because we pursued with the authority and authorities will also with us.
So I am advising you instead of you advising your client.
Well, tomorrow the demolition is,
No, otherwise, what is there for me to interfere? It has attained finality.
so far as this is
You
concerned.
did not do anything. You sat over the matter for 2 years with this judgment. Whereas the same court in another appeal
Same code. Same code. Same issue. Same part.
says that it
Same
has the
part.
jurisdiction.
Yes.
Then your first duty
I
is to
told
seek-
him.
it is why I
Why?
should interfere.
But-
An appellate authority and it has the power of review.
Since
It is a pre-existing judicial authority.
my lordships. Yes,
It is not that a tribunal.
lordship,
It will go by CPC.
lordship.
And the CPC provides the power of review, perhaps.
One prayer, if I may make. If lordship,
What can I do, Mr.?
lordship protects me for 7 days, I at least approach me. This is a thing where court of law has exercised jurisdiction in one and refrained to exercise in the another. And while the GMT authorities are also with the matter.
DMJ concern, DMJ 71 concern. DMJ, no, এখন? It did not struck in your mind.
We did, but then 2 years had already gone by.
No, still it did not struck.
But it was too late in the day when they
No,
noticed.
it is easy for you to file a writ petition at the drop of a hat.
Now it was irreparable loss would follow me.
No, what
By the
you-
time we had the notice, by the time we had the notice.
You had full time since October 2000, is it not?
I leave it to the clients what they did not do.
But
But-
page 52,
Yes.
August 2025.
Yes, that
Now 1 year. Is it not?
now both authorities and us, we proceeded with the matter. It was not that they were acting otherwise. They also called for some report which was not given to us.
That notification has been cancelled by subsequent notification. This is the notification. This notification which the district judge has referred to, that has been cancelled.
So since presently, my lord, the authorities are also not upon doing on the exact positioning of the boundary wall. Only issue is that prior NOC was not sought for.
I think this is a fit case for review when the same
understand.
authority, the appellate authority,
Decided one
has decided one immediately or before that.
after that. 16/5,
After 2 months,
2 months, 16/5.
it has decided it has jurisdiction to decide such matter
And on March,
and referring to a notification which has already been cancelled as far back in 1996. It has exercised jurisdiction that
I pray for equitable constitution. I pray for equitable. It's not the house, it's the boundary wall. And per se, the act is also not applicable. 85 Act came into force in
no,
92.
those are
No, I'm not-
questions of fact, mister. Don't argue that
I'm not-
when you have not argued before the appellate authority, which can go into the question of facts.
Lordship.
Don't argue that before a read court.
For the equitable constitution, I leave it to your lordship.
Yes, madam.
Lordship, as per my senior's instruction, notice is to be issued, Lordship.
No, notice not. I am not entering in this petition.
Lordship.
But question of equity, 7 days, Mr. Bonik has asked.
Lordship.
Who is your senior?
P. Nayak. P. Nayak, Lordship. He's on legs in court time.
Okay, call him.
Lordship.
But you have gone in a different tangent, knowing fully well the two judgments of the two same
Lordship,
court.
yes. We wanted to place it.
You are not uttering anything.
No, we have placed it in a very tactful manner. My lord. We have treated the paragraph also.
Otherwise, you have no merit in this.
I understand. I understand.
Delay list for admission, another one.
May please your lordship. My lord. Their government is not has not filed any affidavit till now.
Lordship may kindly peruse the order date. 17/11/2025.
1711.
Your lordship order, page 13 of that order, third paragraph. Mr. Purposely Learned Standing Council Revenue Department is required to obtain instruction from the District Commissioner Kamrup Metro on the issues. Firstly, when a parcel of land is recorded as burial ground Kabarstan in the concerned Chitha revenue record, the ownership and title remains with the state or not. And secondly, in what manner and in what kind of entity a parcel of land reserved for burial ground Kabarstan is to be managed and operated, and how such authority is provided. Now, in our affidavit, those things are not there.
Not there.
Not there. We have dealt into other aspects involved in the case. That it is a land reserved for.
See, it is,
Kabarstan.
if I remember correctly, some Kabarstan,
Yes.
Artgaon.
Yes. Adab.
If it has remained as burial ground, revenue record, then everything is vested in the state. And if somebody has been asked to manage, whether it can change the nature and character of the land by renting it out.
There is one notification of our department, pursuant to.
1 minute. Somebody else, something said. Oh, it was said some Mr. Barbuzari. The affidavit filed on behalf of respondent number 3.
Yes. That will cover our, but these 2 points are not covered.
Yes.
It's only a page affidavit. Only nothing has been said about those.
State has not filed any affidavit.
The respondent number 3 has filed.
3 years.
You said which order? November 2025, right?
It was 25.
1711.
Okay, it's to obtain instruction from the district commissioner.
Yes.
So he has filed an affidavit.
Yes, he has filed an affidavit. But
Let us
those
see.
2 points are not covered.
Is it there perhaps? It is there perhaps. He has
Para-
answered
Para 5.
para 3 onwards.
Burial ground reserve, my lord, to such and such. Recorded as reserve Kabastan.
Yes, that part is there.
That part is.
That part is not.
Then second part, para
solely-
4.
Solely for burial purpose, so there is no other question using the reserve land for commercial purpose. Moreover, no competent revenue authority allowed the shop to operate the business. Whether the state has the authority or not, that question.
No, state subject prima facie.
Lord, I appear for the burial committee. Lord, my humble submission would be twofold. There is no dispute that the land is reserved for burial purpose. So therefore, it's a part of the Milord. So will be protected by Article 25 and 26 of the Constitution, number 1. And number 2, Milord, can a summary proceedings like 18 be invoked in such a case?
18?
Rule 18.
Rule 18.
Whether, Milord, it's not that we are ranked trespasser or something. Milord, it's
No,
a,
so far as, what is the question here?
the question is, Milord, they want to evict these tenants. We have permitted them to own their shops because they're paying us rent. We are not getting any grant from anybody. We have to manage the affairs. It's a part of the endowment property.
How endowment property?
Yes, my lord, it's a part of the religious, it's a religious denomination. It's a burial ground. So therefore, Article 25 and 26 will apply.
Okay. Let us,
But these are some of the issues in my humble
let us
sub-
proceed then. All are ready.
Look, I didn't come prepared with all the case laws and all. In that case, Lordship will fix a date, my lord. Shortly, I'll address your Lordship. No, it's a very interesting point, my lord.
Yes, yes.
My lord, as per my seniors.
But are you ready? You are ready? There are 2 entities, right?
2 entities.
Okay. Okay, then. When do you want?
September.
It's first, 3rd, 4th September, my lord. If it is,
4th is holiday.
oh,
4th, 5th holiday. 8,
It will be
10, my lord.
10 September.
in September.
10 September.
Okay, PK Rai Chaudhary. Heard Mr. PK Rai Chaudhary, Land Senior Counsel, estate by Miss A. Authorised, Land Standing Counsel, Revenue Department. Mr. J. Hendik, Learned Junior Government Advocate, Assam for the respondent number, state response, 2, 3, 4. Mr.
I am
Chotu-
for 5 minutes.
Okay, assisted by A. Dhar or J. Golita?
Edhor.
J. Choudhury, Learned Senior Counsel, assisted by Mr. A. Dhar, Learned Counsel for the respondent number 5. Mr. J. Golita, Learned Counsel appearing on behalf of the respondent number 5. 5 to 12. First of are present. First of yes, Mr. Bodassery, you want to file an affidavit? State.
Yes, no problem.
Mr. A. Bodassery, Learned Standing Counsel,
Lord,
Revenue Department.
I also like Lordship will inquire whether summary procedure can be invoked in such cases.
We'll go into.
Yes, yes.
We'll go into that.
Yes.
At the time of hearing. Has sought for 2 weeks time, that is 10th of September,
Time is
2 weeks
about
time, to file an affidavit on behalf of the respondent number 1. Okay. Post of arrest sought for and agreed to by the Learned Counsel for the parties, raised the case on 10/9/2026. Interim order, if any, shall continue till then.
Lord.
In terms of order dated 17/11.
In terms of order dated 17/11/2025. In deference to.
4. Lord, in this matter,
These affidavits have not turned up.
oh,
He said in the morning, but I also need some time to. Mr. Hussain in the morning said that he wants to bring an affidavit on record, but it will be very difficult. There are
Yes,
many
yes.
questions. Suddenly, if a pleading is filed before the
Right,
court, just I have a tentative view, or not a tentative view, some questions.
yes.
Some questions have popped up in my mind. I will just express first, then not possible maybe today, because one, this provision 111
Related Rule
2F
62.
2F in the statute came in 2023 or 24, along with 111 2F. This rule 62(4) came in, along with the statutory provision. Prior to that, 111 2A, B, C, all those came in. HSL qualification,
Then I
two
think
child, and toilet. Along with those those section 111 A, B, C, whatever, those rules 64
2-4.
2, 4 or some other rules
Rule
came.
62 sub rule 4.
No, some other rules, similar manner, whereby power was given to the district commissioner to decide on 2-child norm, or to decide on this qualification, or to decide on this sanitary something. Those were again amended in 2023. Those rules and those 62 rules whereby this power was given to district commissioner, virus was challenged, appealed. Thereafter, those writ petitions were filed. I'm just sequentially. Then those district commissioner has the power, and Supreme Division Bench has said right from Javed and to another decision from
Supreme Court.
Haryana, Orissa, similar provisions were there. Now, this rule came in. District Commissioner has been given the power. That is one part. By the rule. And normally rule has the same force as the statute if in exercise of statutory power. Now, that virus is,
Happened.
no, this virus is
And
not
that-
tested. Virus is not tested, 11.2F. And rule is also not tested. Virus. So, when this rule is in the statute or
In
is in force,
What would be the position?
right, that he does not have the competence to decide on the matter without saying that this rule cannot be acted upon. That is one point. This is just, I'm so that
Loud thinking.
loud thinking only. One part is okay. I have seen that reference has to become from upwards,
Yes.
not from top down, bottom up,
Ascending on.
ascending order. That is one, that is, I have no issue. Secondly, thirdly, by saying that an election petition is maintainable,
Yes.
not by this manner. And statute says, I don't know what is the meaning, direct election petition. And the state government has carved in consultation with the High Court, limiting an election petition only to a contesting candidate. So in a constituency or ward of 10,000, let us visualize. In a ward of 10,000 in a Gaon Panchayat, suppose there are two contesting candidates. One won, one defeated. Only that
He alone has
man can have,
grievance.
no, can file an election petition.
In other words, Milord, he alone can maintain a petition.
So 9,998
Person is being debarred.
debarred. It is not the case in MLA or MP cases. An elector can maintain an election petition. So what will happen to those 9,998 persons? If we limit it to a election petition only, then they do not participate in the nomination scrutiny process. Right? So these are some questions that this only two. One is one. One
If it-
person he has got elected. He has no grievance. Only one will remain. Suppose there are only two candidates. Only one can have the grievance. The remaining electors in the ward, they cannot have any
grievance.
legal recourse. That is what.
Correct.
Not as a,
No,
I am
Lordship has-
seeking
Lordship has
assistance
very-
of Mr. Chaudhary and Mr. Dotto
No, Lordship's articulation is absolutely, Milord.
as an officer of the court.
Yes.
Apart from other role, that what will happen to those?
So therefore, how to come out of this situation? I'll address your Lordships on all the 4 points.
These are few I could remember. And resorting to RP Act, when the law is there by the legislature of the state. So these are few other issues.
I think
This-
whether Lordship has noticed Rule 54 of the rules.
50,
54 of the rules.
45.
54.
No, I am in that election
No,
petition.
54.
So these are cropped up, just cropped up. So I have
Similar,
expressed.
as regards other matters not provided in Assam Panchayat Constitution rule, matters shall be guided by relevant rules under the representation of people.
Muted is muted.
Muted.
Right. All these are to be gone into. I have seen it.
Well, I was only going by the preponderance of the judicial view, my lord, and having regard to the constitutional prescription. My humble submission is, my lord, yes, section 1112F, read with rule 62(4), would operate in a situation where the nomination is not accepted. Once nomination is accepted, candidate takes part, then there is an election, then there is a declaration of the result. Then, my lord, I don't think 111(2)F and rule 62(4) can be applied. I'll try to satisfy your lordship broadly.
We'll
on
look
this
into
point.
it because it is not that
Yes,
the other three situations.
yes,
It is completely dissimilar to 111(2)F.
yes.
Two-child norm, sanitary napkin, latrine,
Electric.
then qualification. These three aspects, virus have been upheld. And not only by this court,
Also by.
five, at least could lay my hands on 5 Supreme Court judgments. And this is not unlike,
Regarding,
that
this is
can
this
see-
is a qualification. We are not concerned with qualification. We are concerned with what is the remedy of a person. Supposing a person is elected, election is over, then what is the remedy? I think the issue boils down to that. Well, for a moment, it is not our
No,
case.
on the other 3 cases also,
Huh.
same situation. It is not that a different situation. It can be after that, aftermath the election also.
And Lord,
Well, we'll look
regarding-
into it. I'm not
Yes, yes.
saying,
No, no.
I'm just
Tentatively,
putting the
even
prop.
If yesterday
It would have been better
Hmm.
if the Mr. Chaudhary or Mr. Datta could take up the before proper forum so that it could have been on a
Yes,
larger
I
forum.
followed.
Larger forum.
And then Lordship will fix an early with Lordship.
And one thing more, suppose I go in a different tangent, but still that he has a competence. If I say, then there are other aspects. How this complaint emanated and whether the district commissioner, if he has the authority, whether he has followed the principle of natural justice.
Yes,
That is another aspect,
yes, yes.
right?
That will be, in fact, that should be the first pillar.
Yes, for that purpose, I think a affidavit from district commissioner
Is required.
is required along with the records.
Yes.
Suppose,
I followed. Lord.
have you understood? Because he has to file an affidavit.
Yes.
And if that, and suppose if I held it otherwise, and thereafter go into the other aspect.
That will be relevant.
Yes, whether he has followed principle of natural justice, whether he has served the inquiry report,
Yes.
giving opportunity of hearing to rebut and present her or his case,
Yes.
that is another aspect.
Correct.
I don't know what will happen on the first issue, but these are easier issues.
Yes.
Yes, Mr.
And my
Doctor.
lord, one thing, looking into just going through the affidavit that is being filed today, my lord, there are allegations against me about manipulating the birth certificate of the writ petitioner. Now, in just keeping in view that allegation, my lord, I think, my lord, it will be appropriate if your lordship calls for the records, because 2 birth certificates are from 2 different.
Let us have the counter affidavit from the district
State, yes.
commissioner.
He
District.
proceeded in the matter.
Yes.
Assuming, my lord, he is otherwise competent to do so.
Assuming. If the larger issue is not to be decided,
Ah,
it can be
then
decided.
It will be easier for the honorable court. Yes, yes.
Right. And thereafter we'll go into this.
Yes, yes.
This birth certificate, if required. So, Mr. Roy, you have to file the affidavit from Deputy Commissioner. I think that will be better.
Yes, yes. Can it be on Monday next or it will be too early? My lord?
It will be too early. I have already,
No, no, no.
can it be,
Thursday,
any day after 11th?
15 will.
15? কিবা সিরিজ টিরিজ আছে নি কোনটো হ্যাঁ কন্ট্রাকচুয়াল এটা আগবেলা কৰিম সেইটো 2টা বজাত নহয় জানো 15 না
15/9.
Develop.
Heard Mr. So-and-so, K. Choudhury, assisted by M.I. Hussain, S. Doctor, Standing Counsel, 1356. Where is Mr. Dubey? R. Dubey. You have any role in the process? Okay, ASAC 2. SS Roy. 4. Mr. S. Dr. Lance, Senior Counsel, assisted by Mr. H. R. Ahmed. For the respondent number 7. First of having regard to the issue who's involved in this case from an affidavit from the respondent number 4. We also put 1 also, department. Respondent number 1 and the respondent number 4 appear necessary. First of both Mr. Dr. Standing Counsel, PNRD, and Mr. Roy, Junior Government Assam, have sought for time till 14/9/2026 to file their respective counter affidavits. As sought for the learned counsel for the parties, released the case on 15/9. Whatever we come across similar cases, we put it on 15/9. There are many other cases.
Yes.
Mr. Roy shall also make endeavor to obtain the necessary records regarding the proceedings leading to the passing of the impugned order dated, what is the order?
23/7.
23/7/2026.
Apply.
Madam. Yes, Mr. Nag has come. We could have obtained an assurance from Mr. Nayak. Okay, let him come.
For hearing, item number 5.
This is an appeal preferred by Union of India, my lord, ex parte appeal, whereby my claim for vehicle damage was
Let us read the judgments.
My lord.
Everything will be clear.
No, small judgment, my lord.
Let us read
Page number.
all together.
10,
Page
10, my lord.
10.
Type copy, my lord.
Yes.
9/2/2011. The claimant's case is brief is that on the relevant day of the accident, an oil tanker having registered number so and so was parked on the left side of the National Highway 37 just near the main gate of the Air Force Station Sabua, without however keeping the parking light on the backside of the vehicle, and as a result, the driver of the defense vehicle having registration number so and so has dashed the said parked vehicle while coming from the opposite direction. Due such accident, the vehicle of the defense got damaged due to wrong parking of the aforesaid oil tanker on
Left
the
side.
roadside.
Left side.
Left side. Left side. That is there.
Left side is correct side or not?
Left side is correct side.
Correct side.
But
No, you say parking light.
Yes.
At what time?
night.
Where?
During
I see how to-
during night hours, without putting any parking light so as to attract the attention of the other vehicle. In these circumstances, the claimant instituted the present case seeking compensation. Malat, none has contested the case, Malat, it was ex parte
Let us read the OP's.
office.
Hmm.
The office who are the owner as well the driver of the said parked vehicle and the insurance company of the said parked vehicle didn't contest the proceeding despite service of notice, therefore the case proceeded ex parte against them. In course of hearing, the claimant examined as many as 3 witnesses and admitted into evidence certain relevant documents. I have considered argument of the land counsel for the claimant and produced the evidence of on record PW1 or the driver. Although in the Air Force, he deposed that at the relevant time of accident, he was posted at 14 Wing Air Force Station Sabua, according to him, on 12/6/1998, while he was on duty and driving a defense vehicle on reaching short of the Air Force Station main gate, Sabua. A vehicle came from opposite direction with full speed and high beam light. Although he dipped his light several times, the driver of the other vehicle did not respond. As the said vehicle started coming very close to the defense vehicle, he then applied brake and had to take 90-degree turn across the railway track of the Air Force Station through the main gate. As a result, he dashed an oil tanker having registration of so parked on the left side of the road, causing damage to his own vehicle and injury to certain severe service personnel.
Then applied brake, he had to take 90-degree turn.
My lord. My lord. Because that vehicle was coming from the opposite direction with high beam.
So according to him, these two are with the vehicle.
Yes,
This with a high beam light.
Yes, my lord.
So he made the dipper, and this was coming in a
My lord.
rash and negligent manner. So he turned 90-degree.
My lord.
90-degree.
My lord. And dashed with the my lord, parked vehicle in the left side.
And which is on the left side,
Left side. But without
not
any-
on a wrong side.
not on the wrong side, but
But
at night
90-degree.
time. Night time.
No, this
90
question is about 90-degree.
Yes.
Not that this, it is not that this way,
Slight, my lord.
right? That this vehicle on the left side was there. Right? It was there.
It was there. It was there, my lord. But
He turned
he turned.
and
Hit in the
hit,
backside.
hit backside or
Backside.
no, not backside. There's the said parked vehicle while coming from the opposite direction. He
From the
said,
opposite side. The said oil tanker was parked on the left side of the 37 number main gate. So without keeping parking light on, the defense vehicle had knocked down the said oil tanker.
no, backside.
Yes,
Backside actually.
backside.
So the eyewitness who drove the vehicle, he said 90-degree.
Because of the that
I could understand that this is a road.
my lord.
The vehicle is coming from this side. He was going from this side, and this vehicle was parked here. And to save him from collision with the vehicle coming from opposite direction, he turned towards the left side,
Left side.
and this vehicle was parked.
My lord.
He
He
hit
dashed,
it,
my lord.
but it is not his case. He
Turn 90-degree.
90-degree.
Uh,
Is it not?
And
Then let us see.
as a result of the accident, the defense vehicle got damaged and the accident took place due to recklessness of the act of the driver of the said tanker. As the defense vehicle belonged to
Which part?
what I am reading.
As a result, he dashed oil tanker parked on the left side, causing damage to so injuries to certain. Injuries to certain.
Defense personnel, malat personnel who are malat in the vehicle of the present vehicle.
That vehicle.
Yes, ma'am.
Hmm.
As the defense vehicle belonging to the
The seat
government of
was
India
parked on
and
the
amount
left
of
side of so and so.
2,100 with interest to awarded in favor of government of India and the same be payable to the jointly in favor of
Give side to the
PW.
other.
PW2 is an Indian Air Force personnel posted at Air Force Station Sabha
Hence, the defense vehicle belong to so and so. Yeah,
at the relevant time. He stated that PW2 money. PW2 is an Indian Air Force personnel posted in Air Force Station Sabha at a relevant point of time, my lord. He stated that the defense vehicle was involved in the accident and got damaged, and a loss of the damage had been assessed by the competent person on so and so and so. The defense vehicle on routine run had met with an accident, as a result of which it got damaged. At that moment, an oil tanker was parked on the left side of the road near the main gate of the Air Force Station Sabha, keeping the parking light, for which the defense vehicle had dashed with the oil tanker from behind, causing badly damage to the defense vehicle. In contrast, Sabha PS case number so and so and so. Exhibit 2 is the accident information report. 3 is the photocopy of the another report where particulars of the insurance policy of the aforesaid oil tanker was recorded. Exhibit 4 is the sketch pen of the spot of the accident. Exhibit 5 is the series are the photographs of the vehicle involved in the accident. A technical report was also prepared assigning the damage sustained by the defense vehicle, and it was estimated as rupees 62,100 only. Exhibit 6 is the technical inspection report. The owners as well as the driver of the insurer of the aforesaid oil tanker are liable for the compensation of the Government of India for causing damage of the defense vehicle by negligence act of parking the oil tanker wrongly on the roadside during night hours without keeping the parking light on, so as to attract attention of the other passing vehicles. Coming to the evidence of PW3, he is also an Air Force personnel posted at the relevant time of Air Force Station Sabha. As per his evidence, his affidavit evidence, as the defense vehicle met with an accident when it dashed an oil tanker having accident sensor parked on the left side of the National Highway 37, causing extensive damage to the defense vehicle. He was assigned with the duty of inspection and assessment of the damage caused of the defense vehicle as a result of the accident. Accordingly, he, along with the members of the staff, inspected the said damaged vehicle and prepared technical inspection report Exhibit 6 as such. The total loss was assessed as rupees 62,100 only. Exhibit 7 is the photocopy of loss assessment certificate issued by the Court of Inquiry. In that view of the matter, the Government of India is entitled for compensation of rupees 62,100 only with interest from the office. Above is the evidence as a whole adduced by the witness of the claimant side. On consideration of the evidence on record, it is seen that the vehicle that has been accident so and so was parked on the left side of the road, and it was defense vehicle that was being driven by the PW1 had collided with the aforesaid parked vehicle. According to the witness, it is said parked vehicle which was kept in a negligent manner without putting the parking light was responsible for the accident due to which the defense vehicle got damaged, and for that they sought compensation. Exhibit 2 accident information report shows that the police has registered a case for rash and negligent driving of the defense vehicle being driven by PW1 in the instant case. The owner of the defense vehicle shown in to be the Government of India and the driver had caused the accident due to his alleged rash and negligent driving, for which 2 persons shown to be injured and one of them succumbed to the injury. This fact of death of a person due to the accident suppressed by the witness of the claimant. Suppression of the such material fact would lead to the presumption of that the PW1 was allegedly involved in the rash and negligent driving on the day of the accident. It is admitted by the PW that the oil tanker was parked on the left side of the road. The fact that some person had died due to the accident by the defense vehicle being driven by the driver of the PW1 would show the negligence of the said driver. This is more so in view of the other photographs, Exhibit 5, series showing that the oil tanker was parked on the left side of the road and the defense vehicle dashed the said tanker on the backside, showing the extent of damage of the defense vehicle, which presumably reveals that in fact, it was the defense vehicle which was being driven in a very rash and speedy manner that has caused accident. Therefore, in conclusion, can be reached that the driver of the defense vehicle was not negligent, is being belied by the photographs mentioned above. It is no doubt that true that while driving the night on a national highway, drivers were exempted to be extraordinarily cautious in driving their vehicles, but here in this case, defense vehicle was driven in a rash and negligent manner for which it dashed the parked vehicle and as a result of which a person died and the vehicle got damaged. The police report available in the case record also shows that the case registered against PW1 was suscited for commission of offense under section so and so and so and so IPC. In that view of the matter, the negligence can very well be attributed to the driver of the defense vehicle. Now, if that is so, the question comes whether the present petition is maintainable, seeking compensation by the claimant. It is found from the record that the owner of the defense vehicle involved in the accident was the claimant here in this case, and the person who drove the defense vehicle was suscited for a rash and negligent driving. Therefore, the owner of the defense vehicle and the driver of the defense vehicle cannot be both claimant in the case. In view of the above, I find that the claimant is the owner of the defense vehicle which was involved in the accident, and the driver of the defense vehicle was himself responsible for causing the accident. Therefore, the claim seeking compensation against the owner, driver, insurer, and of the parked vehicle has no merit. Therefore, the present claimant is liable to be dismissed, and accordingly, it is dismissed. Now, my lord, in the same context, my lord, Honorable MSCD and Land High Court, my lord, Honorable High Court, my lord, awarded 50% my lord, award, my lord, to a car which was dashed with a oil tanker parking in the
No,
road,
this
my lord.
case.
No, I'm citing a judgment, my lord.
No, see his evidence now, driver's evidence.
My lord.
See his driver's evidence. Whether, see his driver, I have read driver's evidence.
Mine.
It is, nothing much has been said in the judgment.
My lord, yes.
Do you have the evidence?
My lord, that copy, my lord, I don't remember.
Read this one. Read.
I'm reading from para 2, my lord. That on
No,
12.
no, you read first from first. I so and so not,
My lord,
you leave it.
that I joined to the Indian Air Force, so and so and so. I am serving in the Air Force station. I posted. My lord.
You leave that.
My lord. That on 12/6/98, I was on duty along with so and so of the 14 Wing Air Force at 20 hours, 8 p.m. I booked my vehicle so and so from for routine run from DP Air Force Station Sabua main gate to convey shift personnel to and from transmitter, which is located approximately 5 kilometers from Air Force Station Sabua and route Dibrugarh. I was accompanied by so and so, who was the armed escort, and so who was to take over the night shift duties. After dropping so and so, who was in the afternoon shift, boarded my vehicle for return journey to base of Air Force Station Sabah. While I was reaching approximately 150 meters short of the Air Force Station main gate, a vehicle was coming.
150 meter,
150
sort
meters
of?
short of Air Force Station main gate. Main gate, a vehicle was coming from the opposite direction with full speed and high beam of light. I dipped my headlight several times, but the driver of the said oncoming vehicle didn't respond. The said vehicle started coming very close to my vehicle. I applied brakes and slowed down my vehicle. As I had to take 90-degree right turn across the railway track to the Air Force Station to through the main gate in order to avoid collision with the said oncoming vehicle, whose headlight were on full beam, thereby blinding me. I swayed my vehicle on the left side. I was swinging a little towards my left side on the road. The vehicle ran into the oil tanker, so parked on the left side of the road, causing exceptional damage to my vehicle and injuries of the 3 service personnel. Oil tanker parked occupying left side of the National Highway 37 near main gate of the Air Force Station Sabah without keeping the back and parking light on. Any visible sign or signal presence of the parked oil tanker. I was not rash and negligent driving in my vehicle. My vehicle had knocked down the oil tanker from behind while I was giving side on the coming heavy vehicle from opposite direction. On our defense vehicle was badly damaged. The accident took place for recklessness act of the act of commission and omission of the oil tanker's driver only. I has been
So 150 meter, he came
the-
to know, he made deeper. Then when he came closer, he lowered his speed, according to him,
Man.
lowered his speed. Then crossed a railway track. Crossed 90-degree turn. Right?
90 across
90
the-
degree. Meaning thereby, it was,
near the
have you seen that?
Sabua Malat, yes.
Sabua.
Sabua Malat.
You have seen?
Malat, I went Malat.
Railway track.
Malat.
Thereafter, the gate.
Malat.
Is it not?
Yes, Malat, yes.
So he crossed he slowed down.
Slowed down and crossed.
Then took 90-degree turn. Crossed the railway track. Thereafter, hit the
Malat.
waiting oil tanker from the back side on the left side. Right? Till that point of time, he did not say anything. Thereafter, he said, without backlight there.
Malat, yes.
We don't think anything.
Malat,
And he was surprised
Malat.
that somebody died also.
Malat, yes, Malat, in that case, Malat, yes, Malat. Department has paid Malat and department
He
personnel.
simply said
Malat.
in his evidence that there were personals, but when you filed a claim application, let us see. Court has taken
Malat, in
not a
Personally-
good view of the matter.
that is there, Malat, yes.
Right, because let us have this document.
He is the main witness, but the other witness are only Malat.
Third is he assessed,
Inspection.
he assessed the damage. Claim application.
But
Your photograph.
Malat. It was on the left side, that is there. It was on the left side, about 8 p.m. around, after 8 p.m. Malat. He left at 8 p.m.
Traffic accident report.
But regarding the any injury or that is not mentioned in the petition in the appeal.
Wherefrom he said, the court said that a man died. Police report. Police report, it is mentioned that it is the case is charge-sheeted.
Charge-sheeted.
Case is charge-sheeted. Diseased. Balkrishna Dupatni. He died.
Yes.
You kept silent. For a armed force personnel to say, not to say. I'm not saying that you are telling lies, but you are not saying in your evidence that one man died in my vehicle. Who was a Balkrishna mention is there?
Malad. Name not mentioned, Malad.
It is there. Balkrishna. Who was the armed escort.
Escort.
He was there. But you did not say this man died.
What is there, Malad? The accident occurred, Malad.
In order to shift the buck,
But
just a minute. These witnesses are saying that it was parked near the main gate of the Air Force Station.
yes.
Right.
Malad, 150 meter is nearby.
150 is not a small distance. No. 150 meter is the other one with the headlight on.
Malad, yes. And
And your
actually the
report,
Malad.
you have your own traffic accident report. It said 200 meters from main gate towards DCOM.
150 to 100 is Malad.
Certified raised to write off some cost of such murder significant incident and insurance court of inquiry has been ordered. To NOC. It is by the side of the road, left side.
Yes, this is by the side of the road. Malad, actually, because of the third vehicle, which is actually not come to the light, Malad. Because of that
This
vehicle
expense
coincidentally-
damage to the vehicle
Yes.
has been written off by the authority.
No, Malad, yes. No, but Malad department.
Certified raised to write off the charge the cost of damage to Swaraj Mazda, which met with an accident on 12 June 1998. A court of inquiry had been ordered on 13 June. No individual is held responsible for the loss, and the same is recommended to NOC, I think, against the public.
Malad, department vehicle when got damaged and for Malad department themselves, Malad, because for claiming and all this, Malad, they themselves, they have the Malad, all the Malad, technical teams, Malad.
You know, a court of inquiry had been ordered,
Malad.
and no individual. It is not that only armed personnel. No individual is held responsible for a loss. What does it indicate?
No individual means, malad it's
Only
department.
army person.
Yes, departmental inquiry only about the army person, not otherwise.
This is on the left side.
Malad,
The
yes,
vehicle is on the left side because near to the vehicle there is a tree. Tree cannot be in the middle of the road.
no, it's on left side, malad. Malad, just I am submitting only, otherwise, malad.
Court has taken an adverse view, tribunal, that you have not said that somebody had died.
That may be, malad.
And secondly, his evidence does not indicate
Malad, to that
that
respect,
there is a negligence.
to that respect, malad. One
Not
judgment-
required to be looked into any authority.
malad, that's kind.
On the basis of the evidence on record.
Kindly, malad, for my satisfaction. Malad, small judgment, malad. Here, malad,
Army is not going to be poorer with 62,000.
here, malad, a tanker was parked in the middle of the road.
Not middle.
In malad, here, middle of the road.
Because tree is visible.
No, here, in this case, malad, and a car dash with the malad vehicle, malad. A car coming, malad, passenger car dash with the vehicle.
90 degrees there.
No, that is not there. Dash with
Crossing railway track thereafter 90 degree. Cross railway track.
directly,
Then
directly, only on the point of malad, no parking light. Here, malad, here,
because that fact, those two facts are not there. 90 degree,
and because of the
railway track and left side. Tree.
Here, malad, this parking light was on, off, and in the present case also, malad. And in this case, malad, only 50% were allowed by the Honorable High Court, malad, as contributory negligence. Malad, subsequently, Honorable Supreme Court, malad, allowed 100%. 100% against the tanker, malad. But this is, malad, I have to say, malad, middle of the road.
Where middle of the road?
Malad,
Where is that?
oil tanker without any indicator. Parking, malad, para 23, 23, malad, para 5, then 23,
Para 5.
sub para 23. I found middle of the route. Malad, para 3, malad, para 3. In this petition, compensation.
Para 3.
Para 3, malad. In this petition, for compensation of the file before the motor accident ambulance, it was alleged that the said accident was caused due to the parking of the offending gas tanker in the middle of the road without any indicator or parking light. The claimant examined the eyewitness so and so, which in affidavit gave an account of cause of accident in the following weeks. Malad, in the middle of the road. But one thing is here, malad, take into account that a strict rule of evidence is not applied in the MSCD cases, that is applied, malad. And as malad, no light, parking light on. Now, malad, kindly come to para 23, is sub para 5, malad, para 23, malad, in page number 5, page number 369. The statement of these witnesses clearly established that these were
Para
23, malad, page 369. Para 23, malad. This is sub para 5. The statement of these witnesses clearly established that this was the sole negligence on the part of the driver of the gas tanker, especially when accident was caused on a month, that too at about 10:30 p.m., which is generally time of pitch darkness. In this way, the driver of the car cannot be held in any way negligent in the accident. Moreover, as per Rule 15 of the Road Regulation 1989, no vehicle is to be parked on busy road. Ultimately, malad, and para 10, malad, last page, malad. Accordingly, we have no hesitation in setting aside the finding of the High Court. As a result of the applicants would be entitled to enhance the compensation as determined by the High Court in its entirely without any deduction towards contributory negligence. In other words, we restored the finding of the tribunal rendered on the issue against the respondent and hold that the respondent number one negligent part gas tanker of the offending vehicle in the middle of the road without any indicator parking lights. Well, it was given to that vehicle, parked vehicle.
Yes, Mr.
Also, in this case, a charge sheet was filed against the PW1, who was the driver of the vehicle, Lordship. And they have suppressed the fact that one person died and one person injured, and they have compensated, Lordship.
They had,
And they have compensated.
On
Lordship.
the personal, it's
And when the evidence of record shows that as per the evidence of PW1, that that the vehicle turned into the 90 degrees, Lordship, and thereafter, after crossing the railway line, it dashed against the parking truck. So it has been established that the their vehicle was responsible for the accident, Lordship. There was no negligence on the part which was ensured with us, Lordship.
the accident occurred malat because of the malat would have occurred malat because of the dead vehicle coming.
no, see, okay, we'll come back. This appeal. Under section 173. Motor Vehicles Act, 1988. The MBX for short is directed against a judgment and order dated 9/2/2011 passed by the Motor Accident Claims Tribunal, Dibrugarh, Assam, within bracket the tribunal for short, in MSCT case number 23/2000 post op.
Malat only, I'm sorry, Malat only. Malat, this is additional district and session judge FTC Dibrugarh.
There is okay, additional district
District and session
session judge within
FTC.
bracket FTC Dibrugarh,
Dibrugarh.
within bracket the tribunal for short. By the judgment and order dated 9/2/2011, the tribunal dismissed the claim application filed by the appellant as the claimant under section 166, MB Act, seeking a compensation of rupees 62,100 for damages caused to its vehicle, motor vehicle, bearing registration number 94D 107-607 capital H within bracket Swaraj Mazda, allegedly in a road accident on 12/6/1998 near the main gate of Air Force Station, at Sabua on the National Highway number 37. Postal. A claim application on court. Claim application. In the claim application, where the appellant claimant made impleaded the owners of a truck bearing registration number WB-73 stroke 0715 as opposite party number 1 and 2, and the driver of the truck as opposite party number 3. Full stop. The insurer of the truck was included as opposite party number 4. Full stop. There, the opposite parties in the present appeal, they are the respondents. They are the respondents in the present appeal in the same order. Full stop. In the claim application, comma, it was mentioned that oil tanker, not truck. The oil tanker was parked on the left side stroke beach portion of the National Highway number 37 near the main gate of the Air Force Station, comma, Sabua, without keeping back and parking light on. As a result, the driver of the vehicle bearing registration number so and so, within bracket, the defense vehicle for short, had collided with the oil tanker from behind while giving side to an oncoming heavy vehicle from the opposite direction. Full stop. It was mentioned that the defense vehicle was badly damaged in the accident, and the loss caused to the vehicle was estimated at rupees 62,100 in a technical inspection report dated 12/6/1998, which was exhibited as exhibit six in the proceedings before the tribunal. Full stop. Para. In the proceedings before the tribunal, the appellant claimant side examined 3 witnesses to support the claim. Full stop. The driver of the defense vehicle was examined as CW1, full stop. 2 other witnesses, comma, who were serving personnel in the Indian Air Force, comma, then posted at Air Force Station Sabua, were examined as CW2 and CW3 respectively. Full stop. The 2 witnesses, comma, CW2 and CW3 Jubran. Two witnesses, comma, CW2, comma, SP Jubran, JUGRAN, and CW3, comma, Umesh Kumar Singh, did not testify to the fact that they were witnesses to the accident. Post of para. In the course, the appellant, apart from exhibit 6, comma, the appellant, the claimant side exhibited 5 more documents, PIZ. Exhibit 1, an authorization letter exhibiting, authorizing CW2 to SP Jugran to attend the hearing of the claim application. Exhibit 2, Accident Information Report in Form 54, issued by the officer in charge, Sabua Police Station. Exhibit 3, a traffic accident report prepared at the end of the prepared by wing commander, Indian Air Force. Exhibit 4, see, Mr. Professor, he has deposed, falsely perhaps. Your sketch map indicates otherwise. Yes, Mr. Bhatto, look at the document. See the main gate, railway track,
Yes.
and oil tanker position.
Oil tanker position.
Somewhere else.
Yes.
Is it not? This man has deposed. Is it the correct reflection of his evidence? He said railway track on the main gate.
Well, 150 meter towards the main.
No, his evidence, we'll look into it and this one. He is not saying the correct one.
Road is coming, crossing the railway track. and
Where the oil tanker was there.
It was there. Oil tanker was
And it is on the
Yes.
otherwise extreme side, left side.
there left.
And it is not in railway track and near main gate. How can he say that the main gate? Well, main gate is there.
Malat 100
No, no. What he said, Mr. Porahor, don't
Yes,
try
yes,
to,
yes, yes.
on evidence in black and white. 90 degree. 90 degree is correct.
90 degrees correct.
Main gate.
Main gate.
Then railway track, correct. Then after that, main gate. That was not there.
100 meters.
Is it not? Exhibit 4. Is a sketch plan of the place of the spot of accident. Exhibit 5 was produced, where series of photographs of the vehicles involved in the accident. Poster. The tribunal upon analysis of the evidence on record, comma, reached the finding that the oil tanker was parked on the left side of the road, and a defense vehicle which was being driven by CW1, had PW PW. So PW1, 2, 3. Driven by PW1, had collided with a parked oil tanker. Full stop. Referring to the accident information report, Exhibit 2, the tribunal noticed that the police had registered a case for rash and negligent driving of the defense vehicle, which was driven by PW1. Full stop. And it was the driver of the defense vehicle who had caused the accident due to rash and negligent driving on his part, due to which 2 persons were shown to be injured and another one succumbing to his injuries. Full stop. The factum of death of a person due to the accident was found to be suppressed by the witnesses of the claimant side. All 3 witnesses of the claimant side. First of the tribunal recorded the view that suppression of such material fact would lead to a presumption that PW1 was allegedly involved in a rash and negligent driving on the date of the accident. Full stop. Taking notice of the fact that PW1 had taking notice of the fact that the witnesses had admitted that the oil tanker was parked on the left side of the road, and the fact that a person had died in the accident caused by the defense vehicle driven by PW1 would show negligence on the part of PW1. Full stop. The tribunal observed that such a view was also fortified from the photographs exhibited as Exhibit 5 series, which showed that the oil tanker was parked on the left side of the road and the defense vehicle dashed the oil tanker on the back side, which gave rise to a presumption that it was the defense vehicle which was being driven in a rash and negligent manner, resulting in the accident. And a conclusion can be reached that and the photographs belied the fact that the defense vehicle was not negligent. The tribunal had further observed that the accident information report, EXT Exhibit 1, showed that a case was registered against PW1 and he was charged for commission of the offences under sections 279/304A, 338/427, Indian Penal Code. Full stop. Having analyzed the evidence on record, the tribunal recorded that the negligence could very well be attributed to the driver of the vehicle, defense vehicle. And therefore, the claimant, appellant claimant, whose vehicle was driven by PW1, charged in for rash and negligent driving, could not maintain a claim application for compensation against the owners, the driver, and the insurer of the oil tanker, first of holding that the claim application had no merit, the claim application was dismissed. Post of para. I have heard Mr. K.K. Porafal and it counsel, Central Government Council for the appellant claimant and Mr. K.K. Bhatto, learned counsel for the respondent number 4. Para. Mr. Porafal, learned CGC appearing for the appellant claimant has submitted that the tribunal had erred in reaching a finding that there was rash and negligent driving on the part of the driver of the defense vehicle, and there was no negligence on the part of the oil tanker. So he has submitted that there was exercise of due caution on the part of the driver to avoid the accident, and a collision had occurred when the driver of the defense vehicle collided on the backside of the part oil tanker, which was parked without back and parking light on, while avoiding a collision from with a heavy vehicle coming from the opposite direction. On the national highway with high beam lights. Full stop. He has referred, he has relied upon a decision of the Honorable Supreme Court of India in Orchid Saini versus Oriental Insurance Company Limited, 2018 3 SCC 365. Full stop. Para Mr. Bhattal and its counsel appearing for the respondent number 4 has submitted that the respondent number 4 as the insurer of the oil tanker cannot be saddled with any liability in connection with the accident in question, as the accident was clearly due to rash and negligent act of driving on the part of the driver, PW1, within bracket, of the defense vehicle. Full stop. He has to buttress in support of his submissions, he has referred to the testimony given by the driver, PW1, of the defense vehicle. Full stop. Para. As the issue which has arisen in this appeal due to dismissal of the claim application of the appellant claimant is whether there was any negligence or contributory negligence attributable to the oil tanker, which was hit by the defense vehicle from the backside. Full stop. Para. It is as the driver of the defense vehicle had testified as PW1 before the tribunal, and he was the only eyewitness to the accident, it is apt to refer to his testimony at first. Para. In his evidence on affidavit, comma, PW1 deposed to the effect that on 12/6/1998, comma, he was on duty and at 20-00 hours, comma, he booked the defense vehicle for routine run Roman 9 duty from Air Force Station, comma, Sabua main gate to convey shift personnel to and from transmitter, which was located approximately 5 kilometers from Air Force Stations, comma, Sabua, en route Dibrugarh. Full stop. He was accompanied by an SDT, means sergeant, an SDT, Balakrishnan, as the armed escort, and LAC, Roses, comma, who was to take over night shift duties. Full stop. After dropping, PW1 stated that after dropping Roses, after he dropped Roses, comma, LAC seeing RS, who was in the afternoon shift, boarded the defense vehicle for return journey to the base at base, i.e. Air Force Station. Full stop. While he was reaching, he stated that while he was reaching approximately 150 meters short of the Air Force Station main gate, comma, a vehicle was coming from the opposite direction, with full speed and high beam of light. Full stop. Then he dipped his headlight several times, but the driver of the oncoming vehicle did not respond. Full stop. As the vehicle from the opposite direction was coming close to his vehicle, comma, he applied the brakes and slowed down the speed of the vehicle as he had to take a 90-degree right turn across the railway track to the Air Force Station to the main gate. Full stop. In order to avoid a collision with the oncoming vehicle whose headlights were on full beam, comma, he, having been blinded, comma, swerved the vehicle to the left. Full stop. On swerving a little towards the left side of the road, comma, his vehicle rammed into the oil tanker parked on the left side of the road, causing extensive damage to the defense vehicle and injuries to all the 3 service personnel. Full stop. Then, comma, he proceeded to depose that the oil tanker was parked, occupying the left side of National Highway number 37 near the main gate of the airport station Sabua without keeping back and parking lights on or any visible sign stroke signal of presence of the parked oil tanker. Full stop. PW1 state deposed that the defense vehicle had knocked down the oil tanker from behind while he while giving side to the oncoming heavy vehicle from the opposite direction. Full stop. Para. When such testimony of the driver of the defense vehicle is considered together with the sketch plan prepared by the wing commander of the by a wing commander of the Air Force station and exhibited as Exhibit 4, the sketch plan is found to have projected a different scenario. Full stop. As per the sketch plan, the oil tanker was parked at a distance of approximately 100 meters from the Air Force station main gate. And it was not parked towards, across the railway line, which situate across, which had to be crossed to reach the main gate of the Air Force station. Full stop. As per the sketch plan, the oil tanker was on the left side of the national highway, on the left side of the road, and in the opposite side of the railway gate. Full stop. The photographs exhibited as Exhibit 5 series, showed that the oil tanker was parked on the extreme side of the road and the defense vehicle had hit the right side right side from the back. When the as per the testimony of PW1, the driver of the defense vehicle, comma, due to the speeding, vehicle within bracket bus coming from the opposite direction with headlights on full beam, comma, he got alarmed and he dipped his headlights several times. When he was at a distance of about 150 meters from the Air Force Station main gate. Post op. According to him, comma, when the vehicle from the opposite direction came very close to his vehicle, comma, he applied brakes to slow down the speed of his vehicle. And he had taken a 90-degree right turn across the railway track to the Air Force Station through the main gate. First off, in order to when he swerved his vehicle towards the left, comma, his vehicle rammed into the oil tanker. First off. This piece of evidence is contrary to the evidence emerging from the documents exhibit as Exhibit 4 and Exhibit 5 series. First off. Para. In the accident information report submitted in Form 54, comma, it was mentioned that in the accident which occurred at 8:30 p.m. on 12/6/1998, Balakrishnan Dupatne had died and two persons, CPL Nair BC and LAC Singh Ravi Shankar, sustained injuries on their persons. And all those three persons were shifted to 162 Military Hospital, Dinjan. Full stop. In this appeal, the tribunal had recorded that in connection with the accident, a case, Sabwa Police Station case number 64/1998 was registered under sections for the offences under sections 279, 338, 304A, 427 IPC. And the case was suscited. Full stop. As per the exhibit 1, two exhibit accident information report in form 54 within bracket exhibit 2. The case was suscited on 13/12/1999 by charge sheet number 13. Post up. The tribunal had also recorded that the charge sheet was submitted in the charge sheet. The driver of the defense vehicle, that is PW1, was charge sheeted as accused. Post up. The said factum of charge sheeting PW1 in the charge sheet filed in connection with the Sabah Police Station case number 64/2000 1998 has not been traversed in any manner by the appellant claimant in the present appeal. Para. The appellant claimant is found to have maintained silence as regards the date of Balakrishnan and injuries caused to so and so and so and so, who all were Air Force person. Post up. Admittedly, Balakrishnan was an occupant of the defense vehicle at the time of the accident. Post up. The tribunal had therefore taken an adverse view, had drawn an adverse view due to non-disclosure of such facts while prosecuting while pursuing the on the part of the appellant claimant while pursuing the claim application seeking damage to the extent of rupees 62,100 for the defense vehicle, which was whose driver PW1 was charged as the charged in charge sheet number so and so, laid in connection with after completing investigation into so and so case now. Post. Where from the discussion made above on analysis of the evidence on record in its entirety. It This court is of the considered view that the findings recorded by the tribunal upon analysis of the evidence on record cannot be said to be perverse cannot be said to be without any basis. First off, it is the on a closer scrutiny, on a close scrutiny of the evidence on record in its entirety, it is apparent that the version of the PW1, the version of the driver within PW1 is belied by the facts which had emerged from the documentary evidence. First, where the decision in Orchid signing, the supra, a gas tanker was found to be the offending vehicle. And on the basis after analysis of the after a detailed analysis of the evidence on record, including the evidence of the evidence 777. Who is just PW7?
Seven,
Who is he?
Para 3,
Who is 7? PW7.
Sohan Lal.
Who is he? After including the account of,
Eyewitness.
including the evidence of
Eyewitness.
one eyewitness within bracket PW7 and a site map. EXT P-45. First off. In the said case, it had emerged that the gas tanker, the accident occurred at about 10:30 p.m. on 15/12/2011, and the accident occurred due to collision or the of a Maruti car with a gas tanker which was found parked in the middle of the road without any indicator or parking lights. Which was a busy road. Full stop. In the case in hand, the oil tanker was found parked on the left side of the road. Full stop. As per the version of PW1, the oil tanker was parked after the railway crossing and near the main gate of airport station Sabwa. Whereas as per the sketch plan, Exhibit 4, the oil tanker was parked at a distance of about 100 meters from the main gate and across in the opposite side, and on the left side or left and opposite side. First off. Allegedly, without its parking line on. Full stop. The driver of the defense vehicle had sufficient, is found to have got sufficient time to exercise due care and caution to avoid any kind of accident, collision with the vehicle coming from the opposite direction with high beam lights. First, from the as it can be noticed from the testimony of the driver of the defense vehicle that it was he had got if the testimony of the even if testimony of the driver of the defense vehicle is accepted to be true, then he could have exercised due caution, care and caution while serving, while turning 90 degrees towards his left, at a slow speed after applying brake, to avoid any accident. First. Therefore, the decision in so and so is not found to be of any assistance to the case of the appellant. Full stop. Having, in view of the discussion, made above and for the reasons assigned therein, comma, this court does not find any contributory negligence on the part of the oil tanker which was hit from behind by the defense vehicle and the act and the accident defense vehicle which was hit on the right side, which was hit from behind on the right side by the defense vehicle driven by PW1, whose testimony does not inspire, whose testimony does not inspire any confidence for acceptance as a truthful one. Therefore, the appeal fails.
My lord, in the judgment, my lord, first part, my lord, defense vehicle number perhaps mentioned as 107607H. Perhaps it will be W, my lord. The vehicle number is the first part of the judgment, my lord. My lord has mentioned as perhaps H, my lord.
It was there in the
In the judgment, it is mentioned as W,
W.
my lord.
I read it from your document only.
Sorry, my lord, then it is okay, my lord.
I don't know. Just a minute. Where from I read? W means silo. I said D.
My lord, these okay, my lord. 107607 H, my lord, have said, my lord.
H.
Then okay.
H.
In the judgment, it is written as W.
Okay. I said H.
My lord, yes. It's if
From your appeal memo.
then in judgment, my lord, it's W, my lord. I'm sorry.
Which one is correct?
W, my lord, in the judgment. it is
W. Okay. I read it from your appeal memo.
Oh,
You said
H.
DH.
Yes, my lord.
Which one is correct then? Let me see the claim application. Claim application H. Claim application H.
Then, my lord. Pardon. 2024 matter, one matter is closed, my lord. My predecessor has drafted file, my lord.
Okay. Therefore, comma, this court finds no merit in this appeal, and therefore the same is dismissed.
Should have,
Any representative?
otherwise those matters are over, I believe. I said that.
Okay, let us wait for some time, otherwise.
For hearing, item 6.
May it please your lordship. This appeal is filed against the judgment and award dated 27/5/2014 million. This is injury case, my lord.
Huh?
This is an injury case, my lord.
Injury case?
Injury case. May I read the judgment? my lord?
Yes.
Six, my lord.
Mhm.
Mohammed Jasifuddin Ahmed, the owner of vehicle number so-and-so and the branch manager National Insurance Company Limited, Jorhat, the insurer of the aforesaid motorcycle number so-and-so for awarding a compensation of rupees 12,50,000 on account of injuries sustained by him in a motor vehicle accident. The facts giving rise to this proceeding in brief is that on 7/2/2006, while the claimant was riding on a motorcycle bearing registration number so-and-so belonging to the OP number 1 and going from Dergaon towards Jorhat, and the way at around 7 a.m. near Balijan on National Highway 37 under Dergaon Police Station, the claimant lost his control of the said motorcycle due to bad road conditions, unwanted stones lying on the road, and low visibility due to fog, and fell down on the road side. As a result of said accident, the claimant sustained serious and grievous injuries on his left leg, head, and on other parts of his body. Immediately after the accident, the claimant injured was taken to Dr. Mothuran to Thakur Jorhat for his medical treatment, and after that he was referred to Patna, Bihar for further medical treatment. Due to the accident, the claimant became permanent disabled person and he lost his earning capacity. Dergaon Police Station has registered the case by Dergaon PSGD number 55 dated since. The OP number 1 contested the case by submitting the written statement wherein it is stated that the claim petition is not maintainable. There is no cause of action to file the claim petition. There is no rational negligence on the part of the motorcycle number so belonging to the OP number 1, and it was in fact the fault of the injured who was ignorant of the situation at the relevant time of accident. The contents of para numbers 2, 3, 4, 5, 6, 11, 12, 13, 18, 21, and 22 of the claim petition are not admitted by the answering OP number 1, that the claimant did not receive any grievous injuries which has led to permanent disablement in the said accident, that the claimant's claim is exorbitant, high, arbitrary, and speculative, that at the relevant time of accident, the motorcycle bearing registration number so-and-so was duly registered with the OP number so-and-so by policy number so-and-so valid up to 27/4/2006. Therefore, the answering OP does not incur any responsibility whatsoever to the extent of any compensation. The OP number 2 also contested the case by submitting the written statement wherein it is stated that there is no cause of action for filing the claim petition, that the age, occupation, and monthly income of the claimant as stated in the claim petition is stoutly denied by the answering OP number 2, that there was no rational negligence driving on the part of the driver of the vehicle number so-and-so, that the claimant's claim is excessive and without any material basis, that the claimant never sustained grievous injuries, the cost of medical treatment and period of medical treatment is also denied by the answering OP number 2. Upon perusal of the pleadings of the parties, the following 4 issues are framed to decide the claim case: whether the claimant is entitled to get compensation, if so, to what extent and payable by whom; whether the accident occurred due to rash and negligent driving of the motorcycle bearing registration number so-and-so; whether other reliefs the claimant is entitled to get. The claimant, in order to prove his case, submitted the affidavit evidence under Order 18 Rule 4 of CPC and adduced the evidence of Dr. SCW2. Both of the witnesses have been thoroughly cross-examined by the learned counsel of the opposite party. Further, CW1 exhibited 12 numbers of documents, including the accident report. The opposite party did not adduce any evidence to prove their defense claim. Third argument of both the sides, let me discuss the evidence and record to decide the aforesaid issues. Issue number 2. At first, the issue number 2 has been taken up for discussions as the issue number 2 is the main issue in the instant case. According to the affidavit evidence of the claimant, on 7/2/2006, he was riding a motorcycle belonging to the OP number 1, Mohammed Jasifuddin Ahmed, on the National Highway 37 from Dergaon to Jorhat, and when he reached near Balijan under Dergaon Police Station, he lost the control of the said motorcycle due to bad road conditions, and as a result, he fell down on the road and sustained serious injury. Here I find that the claimant himself is responsible for causing his own injury. Therefore, he is not entitled to get compensation under Section 166 of the MBA. However, the claim petition lies under Section 163A of the MBA, as because he sustained injury in the result of the motor vehicle accident, where the rash and negligent driving is not required to be proved under the said section of the MBA. Hence, the issue number 2 is decided accordingly. Milord, our point in the memo of get compensation under Section 163A of the MBA, Milord, because he was not a third party. He stepped into the shoes of the owner, Milord. issue numbers 1 and 3 as both the issues number 1 and 3 together. Therefore, both the issues number 1 and 3 are taken up together for discussions. The claimant himself drove the motorcycle bearing number so and so belonging to the OP number 1. The OP number 1 allowed the claimant to drive his aforesaid motorcycle. According to the evidence of CW to Dr. Said Najim Hussain, the claimant sustained 45% permanent physical disability of his left leg. The doctor CW2 has stated that the left leg of the claimant shortening and became deformity due to old compound fracture of left tibia. The claimant submitted the list of medical expenditure while in taking the medical treatment due to the injuries sustained by him in the motor vehicle accident. The claimant has stated in para number 13 of his affidavit evidence that an amount of rupees 1,45,927 has been incurred by him for his medical expenses, but the claimant has not exhibited the said medical expenditure statement during the course of trial. Under such circumstances, the said contents of para number 13 of the affidavit evidence has not been accepted in toto. It is true that the claimant expended some amount of money for his medical expenses, but not such a huge amount. Therefore, it is presumed that the claimant has expended an amount of rupees 1 lakh for his medical treatment. The claimant has stated in para number 6 of the claim petition that he used to earn rupees 5,000 per month for his business supplier and contract, but nothing has been submitted to prove the fact that he is the supplier and contractor. As per Exhibit 1, he used to earn rupees 60,000 per annum. The total annual income of the claimant should not be beyond rupees 40,000 per annum, as the case of the claimant covers under Section 163A of the MBL. As per the medical evidence CW2, the claimant sustained 45% physical disablement, but he is a
So suppose your first point, firstly, the tribunal has converted an application under 166 into 163A. This is one. Whether tribunal on its own can empower itself to convert it to 163A. Second, even if 163 is applicable, suppose it can convert. Now he was driving his own vehicle. Any authority on that point?
Yes.
Certain documents exhibited. So whether there is personal cover,
Mm,
have you laid any evidence?
no, look, as per policies. Okay.
So have you disclosed so in your appeal?
No, we look at her.
Yes, madam.
Lordship, your travel was likely passed out in judgment, Lordship. Your Lordship.
Tribunal has converted the application
Yes,
after
application
recording
for-
finding of fact.
Yes, Lordship.
That
There is no,
You were, the driver or
Yes,
the
sir.
rider of the vehicle was at his own fault,
yes, Lordship.
right?
Yes, Lordship.
So you have not preferred any appeal
Yes, Lordship.
on that,
Yes, Lordship.
right? Next is that the tribunal converted it, the application into 163.
Yes,
That is also doubtful.
Lordship.
Whether it has a power on its own,
Lordship, yes, tribunal can,
let us have any authority.
first of all, Lordship, let me explain 163, Lordship, if Lordship allows me.
This has been explained in many judgments, so
So, still, Lordship, I may be allowed to.
the Supreme Court judgment has been placed.
Yes, Lordship.
There it has been explained thoroughly.
Yes, Lordship. That,
Which one is? Supreme Court has explained.
yes, Lordship.
So no point.
Yes. But
At
they,
least in Ram Khilari, very new one, 2020,
yes, Lordship.
2 SSC 550. Right. Before that,
Lordship.
I used to remember it, Ningamma.
Nikamma.
It is explained.
Yes, Lordship. There
You
is no
step
leg-
into the shoes.
And it's a beneficial legislation, Lordship.
Beneficial relation, but you step into the shoes
Yes.
of the owner
Yes, Lordship.
of the motorcycle.
In this
And
regard,
you
Lordship,
committed the act.
Lordship, in this regard, pain recovery is there.
The question is first,
Pay-
whether you pain recovery from whom?
From the owner, Lordship.
Owner, you are the owner.
Uh, uh,
You are the permissive owner.
I'm the claimant, Lordship, here.
So you claim yourself, you pay yourself.
No, Lordship.
Is it
They
not?
have not taken the plea, Lordship. They didn't adduce any evidence regarding this, Lordship.
No, the question is
They-
first.
they have- because,
first is you filed a application under 166,
Yes.
where you had to lead evidence, right, regarding rash and negligent driving
Lordship.
of some other party,
Lordship.
right? Not you.
Lordship.
But here you committed the accident on your own. No other vehicle, nothing was there, right? You did not exercise due care and caution. The accident had happened. You fell down on a road
Lordship.
without there being any other involvement of any other person, not even a cow. Right. So this accident was due to your own act. The tribunal recorded a finding to that effect, right? That there was rash and negligent act on the part of the rider. Now you are the permissive user of the motorcycle. You borrowed the motorcycle from the owner. So you stepped into the shoes of the owner. So you cannot be the claimant and recipient. You can claim then 100 crores also. You have to give it to yourself only. Any imaginary figure you can pick up. Right. Tribunal converted into 163A, where he did not have to prove rash and negligent act. So, in such situation, the rider, who is the permissive user of the motorcycle from the owner, you are the de jure owner, right? Because of the permissive use. So anything can be claimed against the owner, but you are the recipient, claimant and owner of the vehicle. This is the concept. Now, whatever award is made, that is subsequent. By whom to pay? By whom to pay? Whom? By whom? You yourself.
claimant.
That is what,
I'm the claimant.
that has been interpreted.
Yes, Lordship.
You are the claimant,
I'm the claimant.
but you are at the same time owner,
That is a
permissive owner of the motorcycle. Being permissive user of the motorcycle, you cannot make the claim against yourself because insurance, tata bye bye.
That's why, Lordship. Yes.
So you have to give the money to yourself.
Because of this accident, Lordship, I have sustained 45% disability. Lordship.
That I know.
That
That is why I asked the
See the-
question.
Yes, Lordship.
Whether you have
So-
pleaded any personal accident coverage was there or not.
They didn't raise anything like that.
No.
Lordship. Yes.
First, they want to go out. This is from the court side.
Lordship.
Right. Otherwise, as the facts established, it is your own.
That's why, Lordship, the tribunal has converted from 166 to 163 because
Yes.
we need not to prove this, Lordship.
Right. Absolutely right.
Yes.
Let us assume for a moment that tribunal can convert the application from 166 to 163A so moto. After reaching a finding that
There is not.
it is your own act of rashness and negligence, right?
Lordship.
Now you need not have to prove anything under 163A. Okay?
Lordship.
Now you are the borrower of the vehicle, motorcycle,
Yes, Lordship.
right?
Yes.
So you are the permissive user. So you stepped into the shoes of the owner by legal fiction, right?
Lordship.
You have made the claim. Who is to pay? The owner has to pay. Now you are the owner. You have to pay yourself. Have you understood?
Lordship, there's
Being
interpretation.
permissive user of the two-wheeler
But Lordship,
with the consent of the owner,
I do understand, Lordship. But the-
you stepped into the shoes of the owner and by you are deemed to be the owner. So you cannot be the claimant, recipient of the claim at the same time. That has been interpreted. That is why if the motorcycle is not only covered by an act policy, but by a comprehensive policy, or there may be a personal coverage. In that case, you will be entitled to that personal coverage to the limit mentioned in the policy. Ms. Roy has fairly admitted that there is a coverage of 1 lakh.
I'm very much sorry, Mila, the policy they have, the vehicle number was mentioned wrong.
This is not in evidence. We do not have to decide.
They didn't reduce it.
Not required. I can simply cut you out.
Lordship.
But I am trying to find out whether personal coverage is there or not.
Lord, I am very much sorry, the policy which was in my hand, this vehicle number is next to you, so I have to take information from the company, that the personal accident.
And what judgment you are suing? 2019. 12 versus 2019, 12 versus 398. This Ramchallari judgment, whether it has taken out of 3 judges bench in Sunil Kumar. Sure. But there is another judgment, Sunil Kumar. 3 judges. Right. Do you have the insurance policy?
Doesn't have, I have to take information, because the policy which I told to the lordship is wrong. Vehicle number,
Hmm?
vehicle number does not match.
Yes, madam. There is anything?
My studies are very complicated. That plea, Lordship.
We can only observe if it is covered. No, they have
Otherwise, Lordship,
specifically taken the plea because evidence on record is sufficient, the tribunal has held.
Lordship.
There was no there was rash and negligent act on the part of the rider of the motorcycle,
Claimant.
right? Conclusively held. Then it changed the application into 163A. Under 166 also, you do not, you are not entitled to any
Lordship.
compensation.
Lordship.
Now let us examine 163A.
Lordship.
If we examine, then there are two clear, at least 5 clear decisions of the Supreme Court
Lordship.
against you. So we can only observe if this insurance policy covers any personal accident coverage, then they should be paid the amount, like it has been held very recently in Ramkiller, Raspera. Perhaps Raspera. And Korean benches have also held in a similar manner. Right. Yes, right. Also for the also for the limit. That's point number 1. Yes, appeal under section 173 Motor Vehicles Act 1988 as amended. Within bracket, IMD for short. Is directed against the judgment and award dated 27/5/2014. Passed by member, Motor Accident Claims Tribunal, Golaghat. Case number 108 of 2006. So by this judgment and award dated 27/5/2014, Commander Tribunal had awarded an amount of rupees 3,45,000 against the appellant as the insurer of a two-wheeler. Motorcycle. Yes, hero and ammunition. I get close. Hearing is number ES dash 03 stroke D dash 0614. For my allowance, interest at 6% per annum on the date of filing of the claim application till date. Full stop. Yeah. The claim application was filed by the respondent number 1 herein as the claimant. Under section 166. Will please take your seat. Read it. Section 140 of the MB Act. Seeking an amount of compensation. Seeking compensation of rupees 12,50,000 on account of injuries sustained by him in an accident. Post up. The claim application was registered and numbered as MAC case number 108/2006. Post up. In the claim application, comma, the owner of the two-wheeler, owner and the insurer of the two-wheeler were treated as opposite party number 1 and opposite party number 2 respectively. Post up. On receipt of notice, both the opposite parties contested the proceeding by filing a written statement. Post up. Before the tribunal, the claimant side examined two witnesses, namely, comma, CW1, witnesses, also the claimant examined himself as CW1 and A and 1. Dr. Syed Nazim Hussain was examined as CW2 to depose in respect of the permanent physical disability sustained by the claimant due to accident. Post up. After consideration of the evidence, yes, oral and documentary, yes, laid before the tribunal, comma, the tribunal, comma, by the judgment in a award dated so and so, comma, allowed the claim application on contest by determining the compensation amount at 3,45,000. For the
Sorry to interrupt, Lordship. Yeah, Lordship, the sumo to conversion, one judgment is there, Lordship. Lordship, may.
Yes. The just and reasonable amount of compensation. Post op. The tribunal directed the appellant insurer of the two-wheeler to pay the amount of compensation to the claimant along with interest at 6% per annum from the date of filing of the claim application. That is, 96. (2006) till payment. Post op. The appellant insurer was directed to deposit the awarded compensation with interest within 60 days from the date of the judgment and award. Post op. Which paragraph? There has to be an application before the tribunal, not suo motu. If you read In the claim application, comma, it was mentioned that on 7/2/2006, comma, while the claimant was riding the two-wheeler, comma, which belonged to the opposite party number one. And the claimant riding the two-wheeler, comma, which belonged to the opposite party number one, comma, was proceeding from their town side towards Gauhati side. Post office. During the journey, when he reached a place near Balijan on National Highway 37 under Dergaon Police Station at around 7 a.m., comma, he lost his control of the two-wheeler due to bad road conditions and stones lying on the road and low visibility due to fog, and fell down on the roadside. As a result of the accident, comma, he sustained serious and grievous injuries on his left leg, comma, head, and other parts of his person. Immediately after the accident, comma, he was taken to a doctor in Gauhati for his medical treatment. Subsequently, comma, he was referred to Patna, Bihar for further medical treatment. It was stated that due to the accident, comma, the claimant became permanently disabled and he had lost his earning capacity. Before the tribunal, the OP number one in his written statement mentioned that the two-wheeler was duly registered, was duly insured with the opposite party number two as insurer by the insurance policy number page 7 of the third line from top with validity up to 27/4/2006. And therefore, he was entitled to be indemnified by the insurance to the for any amount of commission to be awarded by the tribunal. On the issue, one of the issue whose framed was whether the accident occurred due to race by the tribunal was whether the accident occurred due to rash and negligent driving of the two-wheeler motorcycle bearing registration number AS03/D-0614. Full stop. Para. Not like the tribunal Consider the testimony of the claimant CW1. Wherefrom, where it was mentioned that on 7/2/2006, he was riding the motorcycle, the two-wheeler, belonging to the opposite party number 1, on the national highway from Dergaon to Jorhat. And when he reached near Balijan, under Dergaon police station, he lost the control of the two-wheeler due to bad road conditions. And as a result, he fell down on the road and sustained serious injuries. Post-op. On the basis of such evidence, the tribunal reached a finding that the claimant himself was responsible for causing his own injuries, and therefore he was not entitled to get compensation under section 166, MBA. Post-op. As this finding of the tribunal was not challenged by the respondent number 1, the claimant, by filing any appeal, the same is to be treated to have attained finality. Post-op. After holding that the respondent number 1 claimant would not be entitled to get compensation under section 166, MB Act, the tribunal on its own had converted the application under section 166, as it was originally filed, into an application under section 163A of the MB Act, on the premise that the claimant sustained injuries as a result of the motor vehicle accident, where rash and negligent driving would not be required to be proved under section 163A MB Act. Post-op. The other the other two issues framed by the tribunal were in respect of one, whether the claimant is entitled to get compensation, if so, to what extent and payable by whom, ? And Roman 2, whether other reliefs of the claimant is entitled to get, ? The point raised, in view of the point raised in this appeal by the insurer as the appellant, it is only the issue regarding entitlement of the respondent claimant to receive, to be awarded compensation under section 163A MB Act request consideration. The contention advanced on behalf of the appellant insurer is that as the respondent claiming was the permissive user of the two-wheeler having borrowed it from its owner, would not be entitled to get compensation. Is not entitled to get compensation under section 163A as as the claimant had stepped into the shoes of the owner. The other contention advanced in this regard, in this connection, is that the tribunal would not have converted the application, initially filed under section 166 of the MB Act, show moto into a claim application under 163A, of the MB Act. Post of. The issue, the first issue, first of the above two issues, is the first issue. The first. The first of the two issues, first of the above two issues, is no longer a integra. It is covered by the decisions of the Honorable Supreme Court in Lingama and others versus United India Insurance Company Limited, 2009-13 SSC 710. And Ram Khilari and another versus United India Insurance Company and another, 2022 SSC 550. And a decision of the coordinates of this court in MSC Appeal number 79/2020, within bracket the National Insurance Company Limited. This becomes close to another. Fair enough. From the above authorities, it is relevant to mention that section 163A of the MB Act was inserted in 1994 by way of a social security scheme. For reference, section 163A is potent hearing below. Well, the provisions in section 163A has been inserted to provide for a new predetermined structured formula for payment of compensation to road accident victims on the basis of age, stroke, income of the deceased or the person suffering permanent disablement. The said provision has an overriding effect as it contains a non-obstacle clause in terms whereof the owner of the motor vehicle or the authorized insurer is liable to pay compensation in case of death or permanent disablement due to accident arising out of the use of motor vehicle, as indicated in the second schedule, to the legal heirs or the victim as the case may be. In Ningama Sutra. The disease was traveling on a motor two-wheeler within bracket motorcycle, which he borrowed from its real owner for going to his native place. When the said motorcycle was proceeding on a national highway, a bullock cart proceeding ahead of the motorcycle carrying iron stick suddenly stopped and consequently the diseased rider, Ramappa, who was proceeding on a motorcycle, dashed against it. Consequent to the aforesaid accident, Ramappa sustained fatal injuries over his vital part of the body and on the way to government hospital. He died. The claim application was filed by the wife and son of the diseased, diseased Ramappa. It has been held that in a case wherein the victim died or where he was permanently disabled due to an accident arising out of the motor vehicle, in that event, the liability to make payment of the compensation is on the insurance company or the owner, as the case may be, as provided under section 163A. But if it is proved that the driver is the owner of the vehicle, in that case, the owner could not himself be a recipient of compensation, as the liability to pay the same is on him. The said proposition, the Honorable Court, Supreme Court has held that the proposition is absolutely clear on a reading of section 163A of the MB Act. And And accordingly, the legal representatives of the deceased who have stepped into the shoes of the motor vehicle could not have claimed compensation under section 163A of the MB Act. Applying the same principle into the facts of the case, the Honorable Supreme Court held that the claimants were not entitled to claim compensation under section 163A of the MB Act, as the provisions of section 163A is not applicable to the facts and circumstances of the said case. Full stop. The Honorable Supreme Court has further held that the claim is made by the legal representatives of the deceased under section 166 of the MB Act. It has to be proved that the deceased was not himself responsible for the accident by his rash and negligent driving. And it would be necessary to prove that the deceased would be covered under the policy so as to make the insurance company liable to make the payment to his heirs. Full stop. Fair enough. In Ram Khiladi Supra, Honorable Supreme Court has made the following observations. No, in Ram Khiladi, comma. In the case of Ram Khiladi, Supra, the disease was traveling on a motorcycle. An accident occurred. On account of rash and negligent driving of the rider of another motorcycle. The legal representatives of the disease filed a claim application before the under section 163A of the MB Act only against the owner of the motorcycle, which he was riding, and its insurance company. Neither the driver nor the owner of the insurance company of the other motorcycle were joined as parties in the claim application. Meaning thereby, no claim application was filed against the driver, owner, and the insurance company of the other motorcycle involved in the accident. The Honorable Supreme Court has proceeded to make the following observations. Para 9.3. 9.8. Nine point nine. The coordinates in so and so has followed the decision in Nam planning. Para. From the evidence on record, it has clearly emerged that the claim application has been filed by the claimant, respondent one, that's claimant, against the owner and insurer of the two-wheeler, which he himself was riding. So there was no involvement of any other person in the accident, other than the claimant himself. As mentioned earlier, the tribunal had already reached a finding. That to the effect that the claimant himself was responsible for causing his own injuries by riding the two-wheeler. The claimant is a permissive user and the borrower of the two-wheeler was a permissive user and the borrower of the two-wheeler, which he borrowed from the owner. So he had stepped into the shoes of the owner of the vehicle, which was involved in the accident. And therefore, he cannot maintain a claim application against the owner, as it would amount to maintaining a claim against himself. In view of the above discussion and of course, in view of the discussion and for the reasons assigned therein, this court finds merit in the with regard to the contention raised by the appellant insurer that the payment cannot be competition under section 163A. As he stepped into the shoes of the owner as the permissive user and borrower of the motorcycle from its owner. Therefore, the stands allowed. Holding the appellant insurer is not liable to the amount of compensation awarded by the tribunal in its judgment and award dated 27/5/2000. So as this court finds that the direction made by the tribunal in the improvement judgment and award dated so and so in affixing the liability on the appellant insurer to pay the amount of compensation of rupees 3,45,000 along with interest at 6% per annum is not sustainable in law, and the same is liable to be set aside and passed. Therefore, the judgment and award dated so and so passed by the tribunal. The direction is set aside and passed, huh? And the appeal stands allowed to that extent. Full stop. However, para the neither the claimant nor the appellant insurance had laid any evidence before the tribunal as regards the personal accident coverage provided in the insurance policy number para 17 also, with validity up to 27/4/2006. Admittedly, the accident occurred during the validity of the insurance policy. Also. Therefore, it is observed and held that the claimant shall be entitled to the sum of personal accident coverage providing the same policy with interest at rupees 6%. If any, if any, with interest at 6% per annum from the date of filing of the claim application till realization. In the facts and circumstances of the case, there shall be no order as to cost. So that is the, if any. Sorry, the, some people are saying this case. In view of the order, judgment and judgment order passed today in the accompanying CPS number 248 of 2014, comma, that amount deposited pursuant by the applicant pursuant to the order dated 3/11/2014, comma, is to be returned to the applicant by observing due formalities. I am telling you, the interim order of stay passed in MC in the accompanying application MC number 2950 2014 stands March 24. So you consider the matter, Madam Pusop, if any amount is entitled, the appellant insurer, it is observed that the appellant insurer shall complete the formalities and shall process for finalize entire process within a period of 2 months from today. Yes. Possibly not informed. Mr. Nayak was informed. Any counsel representing him?
Earlier in the morning hours were there, but now probably
Because this is on equity only,
on it.
nothing else. Have you got the notification? 96.
Yes, in a lordship's judgment, I could get that. I checked.
Last line, cancels.
Now that
94.
it goes back.
Cancels the notification and then of 1990.
One
You can have a copy of this
I took it from this judgment.
judgment, but we have a copy. Copy. তারপর তো xerox করে দিবো।
In fact, I should be fair. What my client had texted me in the interregnum period, I did not tell him about the developments of this court. He said, in the event we lose and the wall has to fall, then let there be no bulldozer. I will do it myself. Kindly get me some time, because in the society, some respect is still there.
Yes.
He just told me, I said, okay, I'll communicate with you, whatever.
No, you can, you have a very good ground for review,
Lordship, we have.
right?
Yeah. This was not
Maybe
known to
you
me. I'm
do.
sorry for that. I appreciate
Instead
that.
of knocking the door of this court, you could have straight away knocked the
No,
door of
I
the
did not know about the development, because in the new book also, I did not find it. So I believed it to be true. I thought something went wrong there. And since they misled us,
It's really hard.
absolutely.
That appellate authority, court, he erred himself while passing the judgment in one line in a previous judgment.
March and May.
The second one, he said, I had a jurisdiction. Second one,
Yes,
he had the jurisdiction. He said that he had the jurisdiction. In the first one, he said he doesn't have the jurisdiction.
I am,
Complete wrong, on a wrong premise.
so far as I went wrong as a council, I believed it to be true. I thought he was wrong on the building part and right on this part. And we checked up, in fact, we bought a new book also.
What
to
is
see.
the situation now?
Situation now is that tomorrow it will be demolished. Today, if we get a protection, we move on.
We'll say there shall not be coercive step in against the petitioner. We post it on Friday. Let it come. There shall not be any coercive step in terms of, because nobody is there. I like to pass my order in their presence.
I know.
In terms of the order,
11/8/2026.
as regards the boundary wall.
Yes. That part I can fairly submit. He had a word with
Mr.
us.
Sonic, learned senior counsel, listed by Miss. Post of, but when the matter is called.
Mr. P9 is still on legs in code 18 in the
So-
midst of a hearing, Lordship.
What do you do? 7 years. Oxygen. Oxygen only. 7 years.
In the meantime, liberty will be granted to approach legally. If otherwise, once sub judice, I cannot move also.
No, I close this.
Lordship, 7 days,
I
little bit more
close this.
because Saturday, Sunday would come certified copy and filing will take some time.
7 working days. To
Lordship.
one and 5. My counsel on behalf of Mr. P9,
P9.
learned standing counsel GMDA and GM. What you write, Gauhati Municipal Development Authority? There is nobody like that. There is nobody like that.
My Lordships.
What?
Oh, Jim
Oh, there is nothing.
Metropolitan. The error fell through me. I said correct.
Mr. Boni, you have to be careful with
I am absolutely sorry. In fact,
GMDA for
second time error.
2, 3, and 4, Lordship.
ठीक है.
Full stop. Mr. And senior counsel, the paying for the petition has submitted that the petitioner is at the receiving end of the respondent GMD authorities with regard to of of RCC building he had constructed. A portion of the boundary wall. They constructed around his plot of land. By an order dated 30/2025. amount is included in this petition.
30,
38,
11.
2025. Is it not?
11, 8, 20, 26.
Page 56.
Basically, this is the order.
This is
By
the
an
report.
order dated, by an order dated, not include, by an order dated 30/2025. Issued under the hand of the Chief Executive Officer, ZMDA. Notices were issued to the petitioner for removal of the alleged unauthorized portion of the RCC building and for removal of a portion of boundary wall constructed allegedly in violation of the building bylaws. Post. Subsequently, comma, an order dated. Will be day after tomorrow or what?
Tomorrow,
Tomorrow,
11
an
a.m.
order dated 11/8/2026 has been passed by the Chief Executive Officer ZMDA to carry out, to demolish, to carry out demolition, unauthorized construction for as part of the boundary wall in the plot of land of the petition. So it has been ordered to carry out the demolition of the brick wall at 11 a.m. on 19/8/2026. Para. Mr. Monik has submitted that an earlier point of time. Our notices were issued by the respondent authority in the GMD. Illegally. Violation of the provisions of the GMD Act and the building bylaws by the petitioner in constructing the boundary wall and the building. Referring to when orders were passed by the Chief Executive Officer GMD under Section 88 GMD Act, the petition referred two appeals under Section 71 or 73 of the GMD Act before the court of the additional district judge number 1, Kamrup, Metro, Gauhati.
Initially before the authority, after that direction of authority.
As the appellate authority. Those two appeals were registered, those two appeals, preferred, one after the another, were registered as Miss Appeal number 14 of 2018 and Miss Appeal number
13.
Okay, 13, 2000. 13 to available. Judgment. Number 13 of 2018 was delivered on 16/5/2024, whereas the judgment in Miss Appeal number 14 of 2018 was delivered on 33/2014. 2024. While in Miss Appeal 13 of 2018, the Honorable Court of Additional District Judge number 1, Group Metro Gauhati, decided the appeal on the premise that he had authority to decide the appeal. Same court, while same court in the judgment dated 33/2024, rendered in Miss Appeal number 14 of 2018. Had urged in observing that he had no authority and jurisdiction to decide the appeal. Post on. It is mentioned, it is Mr. Monique. Mr. Monique has submitted that while rendering the judgment dated 33/2024. Had relied upon a notification number NA 133/92/7 dated 11/2/1994 of the Municipal Administration Department, Government of Assam. So, submitted by in subsequent notification. Hearing number CDD 0.49/94/24 dated 22/8/1996 of the Gauhati Development Department, Government of Assam. The earlier notification dated notification number MA 133/92/7 dated 11/2/1994 was cancelled. Meaning that on the date, it is pointed out that in the notification dated 11/2/1994, the appellate authority, sorry, the Assam Board of Revenue was mentioned as the appellate authority. In the subsequent notification dated 22/8/1996, the District and Sessions Judge, Kamrup, Gauhati, had been made as the appellate authority. So meaning on the date of deciding the appeal on Miss Appeal number 14 of 2018,
was the district session just come to Gauhati. Who was the appellate authority? Whereas the learned court had observed that the appeal ought to have been filed before the Assam Board of Revenue. Folks, Mr. Bonik has submitted that the petitioner ought to have approached the appellate authority in the case of two conflicting judgments rendered in this bill number 13 of 2018 and this bill number 14 of 2018, seeking a review of the judgment dated 33/2022. Also fairly admitting that there is an element of ignorance on the part of the petitioner. Mr. Bonik has submitted that the petitioner now wants to approach the appropriate forum for a review of the judgment and order dated 23/2024, rendered in Miss Appeal number 13 of 2018. So as the the petitioner is facing the threat of demolition, which has been ordered to be carried out tomorrow. He has sought deferment of the demolition process by a period of 10 days. In order to enable the petitioner to seek appropriate remedy. Before the appellate authority and to seek appropriate relief, including injury. As permissible. That much I can say. I think considered is that there is some portion in the submission of the municipal council. That is the authority of the appellate. Authority. Point. Now order tomorrow. And
May I just? I will get it from. It is there. Yes, Mr. But who is there?
For hearing, item 7.
Yes, Mr. Bhatta, what is the issue?
In this case, we have challenged the finding on negligence.
Negligent.
My lord, the charge sheet and the FIR both says that it was the negligence of the truck. Whereas the learned tribunal, after recording the evidence, everything, my lord, has come to a finding that the motorcycle is what was at a.
Which one will prevail?
My lord,
Which one will prevail?
my lord, the finding.
Charge sheet or
Charge sheet, charge sheet.
how? Charge sheet. That is a different matter.
Evidence is also.
We have to,
They were
have
hearsay
to
evidence. We have to balance.
we have to see.
My lord, in fact, the
possible
truck was not having the insurance coverage because of that.
Not
reason
possible
it
today, we left it aside. We will
My
not pass any order.
My
It will come automatically.
My lord,
Left over.
my lord,
Because all these are having,
fixed dates, my lord, Tuesday and Thursdays.
no, otherwise, because of the mandate of the Supreme Court, I'm not
Yes.
fixing any date after 1 month.
No, my
Let
lord.
it be
anytime,
left over.
anytime.
If the
Anytime.
registry tackles the issue, it is
My
a
lord,
problem.
my lord.
But at this time, it will not be possible
No, it would require
to
some
hear
time.
you and to declare the order.
Lordship can take any day this week or
No,
that.
left over.
Left over.
Left over.
I am not fixing any
My lord.
dates. Because year-wise it is coming,
Well,
right? 12, 13, 14, that way it will be arranged. So I'll not fix the date.
well, today I had some predicaments, so in the morning it was
No,
mentioned.
no.
I have collected my.
So
Yes.
left over,
Yes, ma'am.
it will come in its own course.
My lord.